comment? Well, let me just, that was great. That was great, Clark. Let me just ask, I guess, make a comment, sort of a question for you to address. So I want to start sort of where you finished. You talk about distinguishing different kinds of rights. First Amendment rights, and obviously substantive due process, so abortion rights, contraception rights. You frame your talk in terms of rational basis review versus intermediate scrutiny versus strict scrutiny. But ultimately where you end up is the court applies what you call real scrutiny for things it calls rights and something less for things it doesn't call rights. Doesn't your analysis sort of ultimately end up in kind of the same place where we debate what is a right? Because if the court were to conclude, sort of the Lockean approach, that an economic right is a real right, not just a right free from irrational state legislation, then you'd have in the same place. You get heightened scrutiny for that right as well. So there's a really distinct issue here from the rights question. And kind of a related point, everybody has their own views of what they see as important rights, whether it's economic rights or abortion rights or other fundamental rights, assisted suicide. But there's, I guess, one right you haven't touched on, and it's maybe the most important right, the right of self-government, right? Which I think most people, was sort of core to the founding. And I guess my question to you would be, does your approach undermine that right in favor of other rights? Now, I understand it's a myth, and certainly when I go to the polls, I don't vote for the legislature that's going to protect my florists, and I mean lots of other good examples. But it's kind of the theory that underlies democracy, that it's our elected officials who decide what's the best policy, the best way to treat lawyers, doctors, florists, morticians, and we have another great example of caskets in Louisiana as well, and not unelected judges. And so it's really a question of who gets to decide. If I've got to err, is it going to be my elected representatives or the judges? Should err on the side of being elected representatives. They might get it wrong sometimes, so might judges, but it's more consistent with the idea of this notion of popular democracy and the right of self-government.
Right. No, I appreciate those. They're great questions, and I appreciate the opportunity to expand on them a little bit. So what I would say is this. The most important thing I think that I want to take out of that and respond to is there is absolutely no right of self-government. It is not in the Constitution. It is not part of our tradition. Unless you're talking about literally self-government. If you want to govern yourself not to eat the entire tub of Ben & Jerry's Chunky Monkey ice cream tonight, you absolutely do have that right. But if you want to prohibit me from eating the whole pint of Chunky Monkey ice cream in the guise of democracy, you have to have a sufficient justification. There is no right of arbitrary self-government, even if we use the term self-government broadly enough to include sort of the democratic process. There is absolutely no right, better way to put it is to say the government has no authority to arbitrarily impose your will on other people. So it comes down to the question of, do you have a constitutionally sufficient justification for imposing your will on another person? And that, I think, makes things, once you clarify it in that way, it makes things both easier analytically and I think less objectionable from the standpoint of interfering with the democratic process. Because I can almost guarantee you that everybody in this room thinks there's at least one area of life, and hopefully a lot more than that, but at least one area of life where you would not submit your free will to purely democratic will. And if the government came along and said, you can't do that thing, whether it's as trivial as eating some ice cream or less trivial like putting your kids in the school of your choice, which is an actual constitutional case from the early 1900s, to whether you can earn a living in this occupation or that occupation, I think most people would say, no, I'm a good American, I'm willing to go along with that if there's a reason for it. Is there a reason for it? And what the Supreme Court has said, in essence, with the rational basis test is, you are entitled to an explanation when the government limits your freedom. It just need not be an honest explanation. And if that's true, that the real key distinction here between heightened scrutiny and rational basis review is whether you get an honest explanation. And as economists might do, let's go ahead and hypothesize an honest government in Louisiana, as whimsical as that might seem. What the government would have said, if they had to come into court and give an honest explanation, is, yeah, we passed that law to protect incumbent florists from protection. That's all that's going on here. That would have been the honest explanation. And then I think that case gets a lot easier. If the government just comes into court and has to give an honest explanation for what it's really doing, I don't think there's some big mystery about whether it's part of our democratic tradition to allow some groups of people to just sandbag other people for purely self-interested reasons. Well, there's actually a circuit split on that point, so I take that back, but we're going to get that split. I certainly yield to no one in my enthusiasm for our constitutional system of government, including the democratic process. But it's not an unalloyed good, and the reason we have a constitution is that we do not live in a pure democracy. And I do believe that one of the things that the Constitution requires is an honest and sufficient justification when the government interferes with your freedom, no matter what you were trying to do, whether it's eating some ice cream, putting your kids into a different school, or putting food on the table. So I'm happy to take a follow-up if I can give a sufficiently big answer. Okay. Does anybody else have questions? We can just sort of start the discussion. Yeah.
You started off with saying, what can ask what's really going on here. Could you explain, like, who are we at when you're saying who to ask? Are we talking in court? Should we be asking our legislators or?
Sure. And that's a challenging one. So let's change it slightly. Let's say it's a Title VII discrimination case, right? And a woman who is, I don't know, secretary at some state agency was fired the day after she told her boss that she was pregnant. But she's also a little bit slower of a typist than anybody else in the pool, right? So now we got a real issue here. Is it conceivable she was fired because she's a slow typist? Sure. Somehow they left her in that position for 5 years without firing her, and then maybe it's a coincidence that she got fired right after she announced that she's pregnant. But in that case, we would try to figure it out because we care. And we care why she got fired. And there's federal law that says we care, or at least that the judicial process is supposed to care. And so the same question could be asked there. Who do we ask? Was this a decision of her manager? Was it some committee within that agency? Was it a legislative decision that said we're not going to have pregnant people working for the state anymore? And so this is really nothing new. This is not some unique challenge that only comes up in constitutional litigation. It comes up all the time. And somehow we figure out who to ask this question of. Again, if it were a free speech case, for example, the government says you have to have a parade permit before you're allowed to have a protest on a town square, and they're charging $10,000 for that parade permit. You could say the same thing. Oh my God, who do we ask? I don't know. Is that the city manager? Do we ask the town council? I don't know. And yet, when we care, we figure out who the relevant decision maker is, and we ask them. Ultimately, of course, if it's litigation, it is the lawyers representing the state who speak for the state. So in a sense, they kind of make the decision whether they are going to come into court and assert, for example, oh yeah, this decision was made at the management level, and she was a bad typist, and that's why we fired her. So it's kind of incumbent on the government, to say, in court at least, assert at what level this policy decision was made. What I would say is when you cut to the chase, in most cases that I work on, what's going on is someone wants to do a particular thing, and the government has either forbidden them from doing it, literally sent an enforcement officer to prohibit them from doing it, or is trying to punish them for having done the thing they weren't supposed to do. And the way I typically frame it in the case is I simply say, what legitimate government end was being served in the enforcement of that law? I don't get too bogged down in how it got passed, and was it 51% of the legislature liked it, but 49% didn't, and they had this debate and they had that debate. Put that all aside. What I generally just say is, what public policy is being advanced by forbidding my client, Sandy Meadows, that was her name, Sandy Meadows, from selling a floral arrangement without your permission? And then I don't care who answers that question. If somebody wants to come in from the legislature and answer it, fine. If the lawyer wants to try to answer it on the fly, fine. I don't care. I'm still going to try and get a true explanation. Not that the judge cares, but I'm going to try to get one anyway. Yeah, behind me.
Are you saying that there's never justification for?
No, so have you ever seen these companies that take down a building, like in an urban area, they can literally demolish it right in its own footprint with explosives? That actually happened across the street from my law firm. It was amazing. If you've never seen that and you get a chance, you would totally watch that. So I would, even as a staunch libertarian, I would say that it's perfectly legitimate for the government to license who can perform urban demolition, and I don't particularly want people learning that skill on the job. So if the government had to come into court and justify that policy, I think they would have a rather easy time doing it. Same thing with doctors, Same thing with lawyers. Do I think that a significant impetus behind licensing lawyers is in fact anti-competitive and protectionist? I absolutely do. But do I think it's purely anti-competitive and protectionist? No. I think there's plausibly something, good going on there. So there would be hard cases for sure, but they would not involve floristry. Or threading or women practicing law. Those are easy cases. And we should at least get the easy cases right. You got skeptical at the end. I thought I had you. No.
I think most of these cases are easy, but possibly in error direction.
Fair enough.
Doesn't the legislature get to decide what the difference between a doctor and a florist? I mean, there is a serious difference, and should they ultimately be the ones who do decide?
Well, only if you don't think there's a right. Because if you say something is a right, to me, the connotation is before someone can prohibit you from engaging in whatever the conduct is, you get an explanation, and it has to be a sufficient explanation. So if somebody wants to say, you can't eat a sandwich, in my libertarian dream world, you'd actually get an explanation for that law, and you'd be entitled to that explanation. And if it turned out that was just Chipotle people wanting you to eat more burritos, that's not a good explanation. So you get the explanation. I mean, again, I recognize this is my libertarian dream world, but in the way I conceive of America as the so-called land of the free, a constitutional republic, not a pure democracy, but a constitutional republic, is when there is a right at stake, you get an explanation. And regardless of whether it's one of these vaunted rights that people write poems about, like the First Amendment, right? And you can't advertise your sandwiches, you get an explanation. For me, it's the same thing you're trying to sell the sandwiches, you still get an explanation. And some explanations will be good, some won't. I'm selling my delicious tainted meat sandwich. And the government won't let me. Well, why don't I get to sell the tainted meat sandwich? Because it's poisoning people and they're dying. Oh wow, that's a pretty good explanation actually. So it's not impossible, it's not that difficult. Some explanations are sufficient and some are ludicrous. Please follow up, I can tell I haven't sold you yet either.
I mean, I understand that. Isn't it the legislature that gets to make the rule about what sort of sandwiches you get to sell, and then the democratic process decides?
Not a constitutional republic. Not if there is, in fact, a constitutional right. I will concede your point if there is no constitutional right to engage in gainful employment, to sell sandwiches. So if you're correct, I'm not, you haven't asserted it, but if it is true, the Constitution says absolutely nothing about making a living, about putting food on your table, then you would be right. Yes, I would stipulate that. But if the Supreme Court is correct in holding for over a century that there is a constitutional right to engage in gainful employment, then you do get an explanation. The government has to have some justification for interfering in that activity. Does that, now are we on the same page?
Yeah. But who sets that line?
The Constitution. Do you think you have a right to carry a gun?
Depends.
Do you think you ever have a right to carry a gun?
Yes.
Okay, but who decided that? Where do you get that? If the people of this state want to just say nobody can carry a gun, what's to stop them?
It's an interesting question.
Well, that was answered in 2008 on a case that I worked on. The Second Amendment has been held to protect an individual right to carry a gun before they can prevent you from having, well, not carry, to have a gun at home, and before they can infringe on that right, they have to give you an explanation. That's constitutional law. That's constitutional law. Yes?
I just want to make sure I understand exactly what it is that you're saying. So are you saying that there shouldn't be a hierarchy of rights and that every time a right is infringed, it should always have the same level of scrutiny? Or are you just saying that economic independence, or however it is that you described it, is something that should be at the higher end of what is?
Thank you for that question, and it's really important. That's the beauty of my insidious plan. I don't care about hierarchies of rights. I don't care about standards of scrutiny. The only thing I'm arguing for is that when called upon to justify a restriction of liberty, for whatever it might be, carrying a gun, eating a sandwich, earning a living, that you get an honest explanation. An honest explanation. Doesn't that sound like a modest ask? If I were selling used cars, I bet you'd buy that car.
Is that what you would call the level of scrutiny then? Like the honest answer, just level of scrutiny?
Yeah, in fact, let me diagram it. So this is probably what most of you have been taught rational or constitutional law looks like. Right? Strict scrutiny, mean scrutiny, rational basis review, and you get this nice sloping asymptote. That's not it. This is what it really looks like. I mean, don't put this on the bar. Put this on the bar exam. But this is what constitutional litigation really is. And this axis right here, this is just the truth line. Everything that happens in a rational basis case is below the truth line. And let me put some teeth on that. That's not just bluster. One of the biggest fights you'll have in a constitutional case is over the standard of review. And if we convince the court to apply heightened scrutiny, very often the government ceases trying to defend the law. They literally just take the ball and go, well, actually, we keep the ball and they go home. But once they realize that they're actually going to have to come into court and justify the restriction with an honest explanation, they don't even try. They just give up. That is literally all I'm asking for, is an honest explanation in every constitutional case. And if you want to have some rights be even higher than that, God bless you. I'll be sitting on a beach drinking a cocktail.
So I think we're running kind of low on time, so
Yeah.
I can, I'll just ask one more question I'm thinking about. So is it possible that we're looking at this framework kind of upside down? So we're looking at it, as though in terms of trying to figure out what rights do people have, when actually what we should be looking at as an initial matter is whether governments of either federal or state levels have a power to implement this action, and then after that, whether rights can be. Is that a?
So thank you for asking me like the most esoteric question in the last. So let me try and do it in 90 seconds. You and I were talking about this earlier.
Yeah, sorry.
One thing that's really challenging if you're into liberty is, something will come up where there's not an explicit constitutional right to do the thing. I could take one pretty notorious historical example. We were huge into eugenic sterilization in this country for most of the 20th century, and we sterilized about 60,000 socially inadequate people. I mean, even I have to admit, if you open the text of open the Constitution and look at the text, there's nothing in there about not having your reproductive organs ripped out by eugenic, legislators. What I would say, though, is before we get to the question of whether you have a right to retain your reproductive organs, there is first the question of whether the state ever had any authority to take them away from you. And the state, again, has to have some legitimate explanation, meaning they are trying to advance a policy that is within the legitimate scope of the police power. And a lot of things are. I mean, if they're trying to protect people from running off the road, and that's why we have stop signs and speed limits and so forth, that's easy. Clearly, that's within the police power. At the other end of the spectrum, if all they're trying to do is help people express their animus towards discrete groups, or shake people down for bribes, or deny accountability, or advance the anti-competitive interests of a bunch of parochial florists in Louisiana, those are not legitimate government ends. And if we hypothesize an honest government, and if the government comes into court and says, oh yeah, no, that law is just purely about animus, just nothing else going on there. Oh, okay, well that's an easy case. We don't even have to get into the question of whether there's a constitutional right to reproduce or eat Ben and Jerry's or, whatever anything else is. If you force the government to come into court and explain honestly what it's really doing, what you'll find out sometimes, again, if you get an honest explanation, is nothing good. Nothing good, nothing constitutional, just literally trying to abuse our power to promote the interests of a discrete group of people. Not always, but sometimes. And then the case is really easy. Good enough?
Good enough.
Thank you guys very much.